On air. Good afternoon, ladies and gentlemen. I will call to order the January 8th, 2026 meeting of the Santa Barbara Local Agency Formation Commission. Madam Clerk, can you please call the roll?
Commissioner Aceves.
Here.
Commissioner Geyer.
Here.
Commissioner Hartman. Commissioner Kiriako.
Here.
Commissioner Lee. Commissioner Magana. Commissioner Mosby.
Present.
Commissioner Nelson.
Here.
Commissioner Patino.
Here.
Commissioner Stark.
Here.
And Commissioner Johnson.
I'm here. I didn't.
Yes. And Commissioner Hartman is entering now. So let the record reflect that Commissioner Lee and Commissioner Magana are absent.
Thank you. At this time, please stand and join the commission in the Pledge of Allegiance. I pledge allegiance to the
flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The first item of business is the approval of the minutes of December 11th, 2025, regular meeting.
Nelson moves.
Hartman seconds.
Is there any discussion? Hearing none, Madam Clerk, can you please call the roll?
Commissioner Geyer. Commissioner Hartman.
Aye.
Commissioner Kiriako.
Aye.
Commissioner Johnson.
Aye.
Commissioner Nelson.
Aye.
Commissioner Stark.
Aye.
And Chair Patino.
Aye.
Motion passes unanimously.
Thank you. Now's the time for members of the public to speak on items that are not on the agenda. Did we receive any requests to speak on items not on the agenda?
Chair Patino, members of the commission, there is no request to speak under general public comment.
So the next item of business is the consent calendar, the approval of the consent calendar. Does any commissioner wish to pull any of these items? Is there any public comment?
Chair Patino and members of the commission, there is no public comment on this item.
Okay, can I get a motion in a second?
Nelson moves approval of the consent calendar.
Hartman seconds.
I have a motion and a second. Any further discussion? Madam Clerk, can you please call the roll?
Commissioner Geyer.
Aye.
Commissioner Hartman.
Aye.
Commissioner Kiriako.
Aye.
Commissioner Johnson.
Aye.
Commissioner Nelson.
Aye.
Commissioner Stark.
Aye.
Chair Patino.
Aye.
Motion passes unanimously.
Thank you. The next item of business is item number 1. Will the clerk please read the item into the record?
Business item number 1 is 2026 LAFCO chairs. It is the selection of chair and vice chair for 2026.
Okay. Do I have any motion? Oh, Commissioner Kiriakos?
I'd like to nominate Stark for chair and Nelson for vice chair, if they're willing to accept.
Is that a yes or a maybe?
I don't think Shane has a choice.
No, that was a yes.
That was a
I
yes.
could rotate with my better self, but
Okay.
that would be fine.
Madam Chair, just remind me what our general protocol has been. I know we rotate, but I'm not sure with the public member how that fits.
Okay, thank you. Commissioner Hartman through the chair. So each year the commission selects a chair and a vice chair. Typically it's done at our first meeting and that person is acting chair or vice chair for the year. Generally, the commission follows a rotational order in which the vice chair slides into the chair position, and then the next category of agencies moves forward. In this particular year, the county member would be a representative that would slide into the vice chair position. So that is the logical order that the commission has been following. And so the nominations of selecting Commissioner Stark and Nelson to hold chair and vice chair positions fits that pattern.
So again, I'm unclear. We've got special districts, cities, county, and public member. So how does the rotation work among those four?
Good question. Go to my report. So the rotational is, each one of those has an opportunity every 4 years to be chair. And so the current rotation is public member would be chair, county member would be vice chair, and then in the next order of rotation is a special district member and then a city member.
Okay.
Okay, thank you. And Madam Chair, is any public comment? Madam Chair, Madam Clerk, any public comment?
Chair Patino, members of the commission, there are no requests to speak on this item.
Was your motion
Okay.
seconded?
Mr. Director Nelson?
Yes, Chair. Thank you, Chair Patino. I'd like to thank Commissioner Kayakis for that. I haven't for that nomination. I'm very much interested in serving as vice chair next year. So I think that typically we try to also rotate within those various members, and I believe that Supervisor Hartman served a couple years ago, so it might be a good rotation to have myself this time, and then when it rolls back around to the next regular member.
Thank you. Okay, I have a motion and a second. Any further discussion?
Madam Chair?
Yes.
Would you please repeat who seconded that motion?
I'll second. I don't think there was a
I
second.
don't think there was.
Oh, there wasn't? Oh, I'm sorry, I thought you did. Okay. Very good. Madam Clerk, can you please call the roll?
Commissioner Guyer,
Aye.
Commissioner Hartman,
Aye.
Commissioner Kiriako,
Aye.
Commissioner Johnson,
Aye.
Commissioner Stark,
Aye.
Commissioner Patino.
Aye. Okay.
Motion passes unanimously.
Thank you. Okay, Commissioner Stark, then we will switch places.
I think you didn't call me, but aye for Commissioner Nelson.
Oh, Commissioner Nelson.
Aye.
Sorry about that.
That's how rumors get started.
Thank you. Well, I'd like to thank Commissioner Patino for a fine year as chair. I hope to follow in her tradition of expeditious business. And in that tradition, I'm going to waive the stirring speech that I was going to give and instead ask the clerk to read business item number 2 into the record.
Chair Stark and members of the commission, business item number 2 is to receive and file a report on 2025 commission activities and adopt a work plan for 2026.
Thank you.
Just hand it to her. Mine's in there too.
Thank you. Mr. Prater?
Thank you. Thank you, Chair Stark. We'll have the PowerPoint up. So this is the time of year where we look back on our year, congratulate ourselves for the job well done, the work we prepared, and thank our outgoing chair for leading us and guiding us through all of that work of 2025. And thank a few more people in my presentation here along the way, and then really look at what's ahead for 2026 and give the commission some perspective on what that workload looks like, and then ultimately ask the commission to adopt that work plan so that we can proceed with the work for 2026. Oftentimes, in the past, we've gone through this. Slideshow hasn't changed much. We kind of changed a few figures and facts. But essentially, the commission held 11 meetings in 2025. We only took one meeting off in the summer this past year. Generally, some years we take both summer dates off. But as you know, in June, we had an urgent deadline to meet our SOLT grant. So we had to hold a hearing in that summer period. In addition, your staff attends and meets with various members of the public, all of our public agency members that are pay into our dues and are members to this LAFCO, and any real local interest that the commission seeks desire to be engaged in. We make ourselves available for all of those opportunities, and we use that as part of our mission to engage with the community, engage with the public, engage with member agencies to build long, trusting relationships. And we do that largely to help us get through the workload that we put forth every year. So this report highlights some of those activities and then looks forward into what's ahead. As always, the county is a main resource for us. The county auditor's office provides financial system for us to be able to pay bills, collect revenues, and then in addition to that, they provide a lot of integral workings for any applications that come forward, as do many of the other county departments. County Administrative Office, County Assessors and Elections, and you'll hear more about what they do when we get into item 3 as the property tax exchange process. We record a lot of our documents with the clerk's office. We record a lot of our CEQA information. And so many of these county departments play an integral role on us to be able to complete the work and get all of what we want to get accomplished done. The surveyor's office does an added role in that not only do they review and approve all annexation boundaries for maps and legal descriptions, they act and serve through a contract as our mapping department. So all of the maps that we produce, particularly in the service reviews that we prepare, all come from that department. And not least or last, the cities and the special districts themselves. As you've heard me say, we can't produce the volume and the types of service reviews without their direct involvement and participation in writing those, reviewing those documents, and providing edits and documentation to that. And then lastly, your staff itself. Legal counsel, both Amber and Johanna, she sat in on a few meetings as well this past year. Natasha and now Isla has joined us. So without that working group, the work that we get done really can have an effect on us. Overall, in 2025, the commission looked at 9 applications. They ran the gamut from amending spheres to annexing territory to out-of-agency service agreements. And then lastly, in December, we initiated the dissolution of CSA 32. And so there's a broad breadth of projects that are there. We still have one outstanding application, the Richards Ranch application. It's still in process. We'll hear later about the status of that in business item 6 today. Other highlights, I won't belabor, is that municipal service review sphere update document. We did accomplish our 5th round of reviews of volumes. which was a milestone for this commission to be able to cover every agency that is governed under us, and be able to write a comprehensive report about what they do and how they operate. We will be starting in on a new, kind of looking back again at the next round, picking up where we left off and adding to that as we move forward in our future years. The commission was mindful enough to recognize the work that we do and provide us an opportunity to include extra help as a part-time clerk so that we can continue to pursue all of the work that we set out in our work plan. This year, the city had made a selection of its members. They changed memberships over as members were not reelected to their seat position at their representative cities, which causes a turnover on LAFCO. Similarly with the special districts. Now, the special districts has recently gone through a number of election rotations, and we're in one still today. We were fortunate enough that Commissioner Johnson was able to win out a runoff election, but unfortunately that was for a short term to fill just a vacancy. So we're now back into an election period, which will be held for a 4-year period. So we're hopeful to fulfill that and have that seat for the full 4-year terms. But if not, there's always a process that allows them to select their representatives. And the big one is the $500,000 grant that we were awarded. So that was a lot of effort to take on, a lot of involvement with the commission, trying to understand what that would entail and us narrowing what that scope would look like. And so this is sort of the first time that LAFCO has stepped into that role and take on quite a task, quite frankly. But we are doing so with partners. And so we feel like the alignment of the partners that we're going to have joining us on this effort, the future contracts that we'll have with them to primarily do that work, will put us in a better position to make future decisions about where growth's going, how we can align our spheres of influence with those opportunities, and give the cities particularly an opportunity to see where they need to plan for in the future. The MOA component and many special reportings that we've done to inform the commission on what your role is, what kind of authorities you have, was all good information pieces that has led to sort of this buildup of knowledge amongst this group of commissioners. So we're excited to be able to offer that opportunity to sort of understand more and provide that in a public forum so that members of the public, our member agencies, can hear that discussion, can understand and have confidence that the decisions that the commission's making are rooted in solid policies and an understanding of what those policies are. And then we monitor all of the state legislation, particularly primarily we do that through the LAFCO arm of our association. They have a ledge committee. I attend all those ledge committee meetings so that we're appraised of what legislation would likely affect LAFCOs moving forward, and then we bring that information before the commission to weigh in on whether or not you want to oppose or support any of those types of bills. And then we produce the budget every year. We collect the revenue out of that budget, and and that in itself oftentimes requires your staff to sort of be the policeman on collecting outstanding debts of the LAFCO balance. And those aren't always paid when we'd like them to be paid. And so throughout the year, it requires us to sort of constantly send out reminders and try to collect the dues that are due. And then lastly, LAFCO has a number of activities. As you know, LAFCO is going through a significant sort of revisioning of what LAFCO wants to become. Again, we have an item on later today to appoint some delegates to be able to make votes about upcoming changes to the bylaws. They're going to look at redistricting the regional map as well, so that delegate will have some responsibilities as to what that looks like. And we want to stay engaged in that. We want to stay engaged in all of the annual sessions that they offer and the workshops that they offer so that we can all stay well appraised of the latest things to do and things to avoid in our role. And then lastly, as I said, we get a lot of phone calls, a lot from the public about where certain projects may be or how does an annexation process work, and we provide ourselves, make ourselves available to any of that so that people are well aware of what that process looks like. So in addition to following up on the two proposals that ultimately that we have, which is the Richards Ranch project and the dissolution of CSA 32, we'll continue processing those in 2026. And as I say every year, there's a list of projects that we get phone calls from interest where they want to do a boundary change or have an out-of-agency service agreement. And we'll show you that list. And that list is very hard to predict every year, whether it's going to come forward any particular time throughout the year. But we know they're working on it. And so at some point, these applications are going to become real, and that'll divert some of our attention away. But we'll always make those applications a priority. They have certain statutory deadlines that we'd like to meet and adhere to. And then in the interim time, we're working on all of our municipal service reviews. And then we're working and continuing to be engaged with the community and our members. So as we indicated here, on the radar spectrum are well over 20 applications that we will likely see. They range in various complexities. We're going to continue looking at our service review program. We're going to take a deeper dive look now into the police, fire, EMS services. It's been 5 years since we prepared that report. This year, we're going to add mental health, dispatching, fuel management organizations. So we're going to take that and start looking at other aspects of services that they provide that we didn't look at before. And then we're going to continue on and look at the trends that were studied from the 5-year report 5 years ago. We'll continue those trends so that we can really understand what do things look like on the ground. We're going to continue our discussions with the City of Santa Barbara about an island annexation agreement. There are a number of islands that the city surrounds that has been on the books and has been difficult to annex and has little interest to annex, either by the landowners themselves or the city themselves. But we wanted to take this opportunity, and the commission has supported in the past, that we want to continue to push that these islands ultimately get annexed in the city because the city is the best service provider. And we want to look for ways to make that easier for the city to absorb those properties. So we're going to continue our discussions on how can we get that across the goal line. And then the commission authorized the records management policy and the opportunity to dive into our office files and start to make some sense out of that and digitize all of that information. So we're working towards that as well, which is another big undertaking. And then all of the other activities are certainly still part of this process. Any elections and appointments that need to happen. Every year I meet with the civil grand jury, and then we've got all the day-to-day operations. We do an audit of our budget every year, so we're starting the thick of that audit as well for '25. Now, here's the list of identified 21 different applications that are on the horizon that we've had communications with either the agencies themselves or landowners that have interest in pursuing some sort of application with LAFCO. And we'll go into too many details, but if there's one on the list, make a note of it, and we can come back and ask me more specifics on that. So as to conclude, what 2025 looked like, and now what 2026 is about to embark, I often like to look at and give the commission a sense of what the next few meetings are going to look like, and what might be coming forward. So in February 5th is our next meeting. We'll be able to likely within the next couple of meetings complete the list of future agenda items. We still have 2 outstanding. Many of them are on today's agenda. 2 more that were added back in December included Isla Vista CSD and their powers and authorities, and SB 499. So we think we're going to be able to address those in February and March. I want to be able to bring back a preliminary draft budget that includes hopefully an opportunity to look at the organizational chart and structure to consider whether or not we can add a 3rd employee. We're going to kick off and initiate the police fire EMS program officially in February. And then in March, I hope to bring back, as part of the educational series, a look at all of the city's general plan and housing status reports that they've produced, so that the commission can get a sense of where the communities are at in relation to what their general plans say, and how well have they produced housing in the recent years. The commission, with their adoption of the records policy, has made some minor amendments to the handbook. So we're cleaning up that handbook. We're adding the new membership makeup, and we've updated all of the registries of all of the cities and special districts under our authority to include all of their personnel and contact information. So we hope to produce that report in March as well. And then LAFCO often holds their annual staff workshop, so we'll be likely attending that. That happens to fall on our March, our meeting day, I believe. This year it's in Pismo Beach, so it's pretty local. And so I think we might be able to still hold our regular staff meetings and have staff just travel back and forth between the conference and attend our regular business agenda.
Is the March meeting is in Santa Barbara?
It is in Santa Barbara.
Easier to go to Pismo Beach. The meeting was in Santa Maria, was it not?
And then lastly, April starts our budget, draft budget proposal. Ultimately, we need to hear the final budget by May, and so we'll start in with the budget series. And if any application comes forward, we'll likely hear those. I anticipate we'll hear the dissolution of CSA 32 in February. I'm already working towards that. So we're off at a fast and furious pace. We're prepared to continue to do a good job and listen to the commission and take whatever direction that you want us to head in, and move forward as our usual charactered pace. So with that concludes the annual report and the work plan. And just a reminder, we are asking for a motion and a second on adopting this work plan as presented. Happy to answer any questions.
Before I ask the commission for questions, could I have a preliminary question? The fact we adopt a work plan basically on the work that comes into the office, is that right? I mean, basically giving us an inventory of the expected business items. So is it fair to say if we adopt the work plan, we're essentially adopting the concepts and the main items that you've done, and if it's necessary to modify something during the middle of the year, we would have freedom to do it?
It is fair to say that, Chair Stark, essentially what the work plan is outlining is it sets out organizational goals, it sets out general goals of how we operate and act amongst our membership. In addition to that, it sets a priority that applications come first, and that will embark on the municipal service review, that we're going to now implement the SOLT grant. And so it sets those as priorities. So whenever the commission throughout the year, if new direction is provided or new opportunities arise, we'll remind the commission that we have a set work plan, and that if there's an opportunity to work in this additional work, we'll be able to do so. If we feel that sets too much of a workload on us, we'll have to readjust those priorities.
Fair enough. Are there any commissioners have any questions and comments about either the information that's presented or the proposed work plan for the year ahead? I have a question which we may get to later on the agenda. And the question is, are we the lead agency for the SALT grant? My assumption is that the hope is that the SALT grant will lead to some sort of deliverable product, either in the form of actual memorandums between the county and various cities, or some sort of model agreement, or both. Is that right?
That is correct, and we are the lead agency on the grant.
Okay, so to the extent that there might be any required CEQA, I'm not saying that there is or there isn't, there's a lot of exemptions that conceivably could apply, we would be the lead agency, is that?
That is correct.
Okay, so we should listen carefully to the CEQA report. That's the only question. I would entertain a motion to adopt the work plan as proposed.
Chair, if I may just ask for a call for public comment?
Oh, public comment, absolutely. Madam Clerk, would you ask for some public comment?
Chair Stark and members of the commission, there are no requests to speak on this item.
Thank you. Would you please call the roll? We
I
have a
I would
motion.
move
We have a
that we
motion.
adopt the work plan for 2026 as presented.
Nelson seconds.
We have a motion and a second. We need a roll call vote.
Commissioner Guyer? Aye. Commissioner Hartman?
Aye.
Commissioner Carriaco?
Aye.
Commissioner Johnson?
Aye.
Commissioner Nelson? Aye. Commissioner Stark?
Aye.
Commissioner Patino?
Aye.
Motion passes unanimously.
Thank you. Work plan has been approved. The next item is business item number 3. Would the clerk please read that item into the record?
Chair Stark and members of the commission, business item number 3 is to receive a presentation from the LAFCO staff and legal counsel regarding the tax exchange process required by state law for an annexation.
Thank you. Staff, counsel?
So, Executive Officer will cover this part, but we do have legal counsel here to correct me if I'm misstate any of the processes. So the commission had requested that staff provide an overview of the property tax exchange process and the particular codes that are applicable to the sections that come up through that process. And I want to be careful in how I characterize generally the overall tax exchange process and make sure that it's kept separate as to what Richard's Ranch process is. It's following the process, but I want to make sure that we're not describing that process particularly. We're just describing generally what the overall property tax exchange process looks like, and what our involvement is and what the code sections say about that. And so the staff report has included a number of attachments for the commission's consideration, a number of flowcharts. I'm going to show a couple of flowcharts up here. But essentially, a tax sharing agreement is required whenever a boundary change is sought. That is basically in order to complete the annexation, Revenue Tax Code 99 provides a particular process that those applications have to go through. The first slide is a flow chart that is identified within a county adopted document that essentially outlines the flow chart of when an application comes in, LAFCO initiates this process through a referral project called a report back. That report back initiates the application process for all of this. And with that, essentially, there's a 45-day period in which the auditor's office has to submit a notice of property tax estimate. And that estimate is then passed on to the county CAO's office, who then initiates conversations with the agency, the annexing agency, to begin the tax negotiation period. Within that 45 days, in order for the auditor's office to be able to prepare their notice, they need to receive within 30 days a letter from the assessor's office. So the assessor's office provides the estimates of property tax allocation. They in turn transfer that information over to the auditor's office. That then sets up the estimates. Those estimates are transferred over to the county CAO's office. And now they have a starting point in which to work from. And they ultimately reach out to the represented city to begin that negotiation period. Because this flow chart is a bit busy and has a number of other things, all of the county departments kind of receive that report back. They all comment on that project, and they all feed into information that the county CAO's office uses to help determine whether or not they're negotiating certain aspects of the project. Some applications include a reorganization that includes a detachment from either a county service area or a county dependent district, which may or may not be ultimately part of the exchange process as it moves forward. And that is all fed into the county CAO's office to be able to understand that so that they can properly begin negotiations. So what I'll flip to outside of this busy process is a much more straightforward flow chart that looks at the exchange process in its entirety. And as I indicated, an application comes in on the left side. It's pretty straightforward. The application comes in, it goes through its channels. Ultimately, the assessors and the auditors provide that information, and it filters down until we move back up and over, and we start the negotiation period. Once the negotiation period starts, there's a 60-day period in which to have that discussion between the two agencies, with an opportunity to extend that an additional 30 days. The extension of that is simply a letter that needs to be written by either party to the other member, also sending it to the executive officer so that we understand that additional time is going to be needed to be able to get through the negotiation process. Within that 60 to 90-day window, the process is fairly straightforward. Either the application, an agreement can be reached by both parties, in which case the application then proceeds through the proceedings at which time we can file a certificate of filing. The certificate of filing ultimately determines that the application is fully complete and ready to take to a hearing. Then we have the hearing, and LAFCO makes a decision on that project. If an agreement can't be reached, then we're more on the right-hand side of the column. No agreements reached. Now we're into a process where mediation gets involved, and then ultimately arbitration can get involved. The timeframes for mediation and arbitration are largely dependent on agreement between the two entities. So if there's agreement between the city and the county to continue having discussions and talks, they can continue to have discussion and talks until ultimately they can reach either some agreement or fail to reach an agreement and proceed on to the next stage. Ultimately, if the proceedings result in no agreement, then the Cortese-Knox-Hertzberg Act kicks back in, and the proceedings to move forward with the project ends in a termination of that application. And again, there's no requirement that agreement be reached by either party. So that concludes kind of the fundamental steps of how you get through the tax exchange process. The codes that are applicable, they're all up on the slide. What I'll conclude with is that in 1981, the county did adopt a master tax agreement. So that is official, it's on the books. That agreement, however, only covers a certain subset of exchanges between certain entities. And essentially, it's a $0 exchange between CSAs, sanitary and sanitary districts, mosquito district, and the Metropolitan Transit District. And largely because their revenues are generated through service charges. And so that's how they collect and generate revenue for their services. And so it's a straightforward application. Whenever those entities are involved in an application to annex, LAFCO uses that master agreement for a zero exchange and immediately gets to be able to file the certificate of filing so that we can proceed to a hearing. Outside of those specific agencies, they have to follow the property tax process. And an agreement has to be met before LAFCO can issue that certificate of filing. So again, if agencies fail to adopt a resolution for that tax exchange agreement, then the proceedings are terminated. And ultimately what that means is that application goes away. A new application that looks very similar can be filed. They can make another run at an application. They can modify the project. They can bring back a similar project and retry to engage with the county on a tax exchange agreement. It doesn't preclude an applicant from having to file a new application with LAFCO when it's terminated. So I'll conclude there so I don't try to confuse the process. It's a pretty straightforward linear process that needs to be followed. And at the end of the day, we either reach agreement or we don't reach agreement, which triggers LAFCO to continue the proceedings accordingly for the Cortese-Knox-Hertzberg Act. So if there are any specific questions about the process and the codes, staff's here to help you.
Let me, if I might, Mr. Prater, let me clarify. The "we" in question does not include the LAFCO. The "we" in question is the county and whatever city and district are combining. Is that right?
That is correct.
My understanding is, and I appreciate being corrected if I'm wrong, once an application is filed, it stays in our file until one way or another the property tax exchange agreement has either been concluded, in which case we can file the annexation position and LAFCO takes over, Or if it's not concluded, then under the Cortese-Knox Act, once there's been a final determination that there is no property tax exchange agreement, then it disappears as a matter of law. We lose jurisdiction over it as a matter of law at that point. Is that right?
That is correct. We are the entity that terminates ultimately that application. So we do have to file a formal termination letter with the applicant at that point.
But it's a form.
That is on us. But as far as the negotiation of the tax exchange process, LAFCO has no role.
We're not involved in it.
Other than to initiate that and monitor the timeline and check back in to see that either an agreement has been reached or has not been reached.
Got it. Thank you. All right, Commissioner Kiriakou appears to have a question or a
I have
comment.
a question, possibly two questions. The bubble chart that had the process flow, the right end of that chart, where it talks about when agencies do not reach agreement, the blue bubble talks about LAFCO deems application incomplete, and then it cites government code and revenue and taxation. So my first question is there anything in either code that provides a specific time frame for which LAFCO to deem that application incomplete? Does LAFCO need to do that within 30 days, 60 days, 90 days? Is it supposed to be like literally instantaneous once you reach the conclusion of the 60 to 90-day process?
Commissioner Kiriakou, through the chair, there is no specific time frame for which us to declare that. Outside of the point of that 90-day period, we automatically need to determine it to be incomplete because we don't have an agreement. Beyond that, the time frames are really negotiated between the two entities. At some point, an agency can declare that they no longer want to proceed in any good faith to proceed forward, at which time we'd be notified of that and we would proceed to the termination clause.
Okay, I actually only have one question then. Thank you.
I believe I recognize Commissioner Sevis.
Thank you. After the two entities have gone through the process and there is no agreement, is there in the law an appeal process for either entity outside of LAFCO?
Ultimately, Commissioner Seves, through the chair, if agreement is reached to go through both mediation and arbitration, the decision, there is no appeal decision ultimately to the concluding of that decision. So the answer is no, there is no appeal of that decision. There is an obligation of the entity that does not want to agree to the terms of the arbitration to make certain findings. And then that decision could be subject to litigation. That's the ultimate caveat that would occur.
So then the only appeal would be through litigation?
Correct.
Okay, thank you.
Are there any other questions from commissioners? Are there any questions from the public?
Commissioner Stark and members of the commission, there are no requests to speak on this item.
I would entertain a motion. Do we need a motion for this? It's essentially an information item, right?
It is essentially, we made it a business item in case the commission wanted to dive deeper into the process and provide any direction to staff on anything further. But otherwise, it's receive and file.
To be careful, clear, there's nothing for us to do at this point, right? The process, whatever it is ongoing, and we're waiting.
In reference to the be clear, I think you're referring to the later item of an actual application that's going through this process. And we can address that when we get to that item, but yeah, essentially, we're waiting to follow the proceedings.
Fair enough. Thank you. I will take the liberty of deeming this received and filed. I don't think we need a vote on it. And we can proceed to business item number 4 and ask the clerk to please read that item into the record.
Commissioner Stark and members of the commission, business item number 4 is to receive an update report regarding Brown Act changes to take effect January 1st, 2026.
So good afternoon, Chair and Commissioners. I'm Deputy County Counsel Johanna Hartley, and I will be presenting a brief overview of SB 707, which primarily became effective on January 1st of this year and made some significant changes to the Brown Act.
Could I ask you to speak a little closer to the microphone, please? Thanks.
Okay, hopefully this helps. So a background of SB 707, which are the modernization amendments to the Brown Act to primarily address technology and how it impacts meetings, especially teleconferencing. The updates from SB 707 that are applicable to your commission include, first, some changes to the teleconferencing options that are available for your commission, including required use of audio and visual technology. Second, 2 new teleconferencing options, including reasonable accommodations for commissioners with disabilities and for eligible multi-jurisdictional bodies. And we'll go through each of the requirements and how these work in a few minutes. And third, are there some miscellaneous changes, such as limits on the use of social media and requirements to provide commissioners with a copy of the Brown Act that we'll also go through. And I'll kindly ask the clerk if she wouldn't mind passing out. We do have copies of the Brown Act, physical copies here available for you. They are also posted online if you're interested. So one of the first and foremost changes that SB 707 initiated was creating a new definition of eligible legislative bodies. And for these eligible legislative bodies, it imposes several new requirements, including special noticing, public participation, interpretation, and translation requirements. So these are really the bulk of the changes in SB 707. So who is an eligible legislative body? Well, these are defined as a city council with a city of a population of 30,000 or more, a county board of supervisors of a county with a population of 30,000 or more, a city council of a city located in a county with a population of 600,000 or more, or a board of directors of a special district that meets some of the following requirements, which include that they have employees, over 200 full-time equivalent employees, et cetera. So accordingly, the Santa Barbara County Board of Supervisors is an eligible legislative body and must comply with these new requirements starting on July 1st of this year. However, LAFCO does not currently meet the definition of an eligible legislative body and is not required to comply with these requirements. Due to that, I will not bore you with all of these requirements, but I will note that there are some significant changes in there, especially in regards to translation of agendas and providing those services. So the next set of major changes in SB 707 are to the teleconferencing provisions. There are now 5 different teleconferencing options: 1 traditional, 2 emergency, 3 reasonable accommodation, 4 just cause, and 5 eligible multi-jurisdictional body teleconferencing options that are provincially available to you depending on the circumstances that you find yourself in, specifically for this commission. So let's start by looking at traditional teleconferencing rules to the Brown Act, which remain the same and are available for your commissioners to use. Under these rules, a commissioner may appear from a remote location as long as the agenda identifies the remote location and the location is open to the public to attend. The agenda is posted at all meeting locations, including the remote location. and at least a quorum of the commissioners participate from within the commission's jurisdiction, in this case from within the boundaries of Santa Barbara County. The remote commissioner must also disclose whether or not any individuals 18 years or older are present with them and their general relation to this individual. And then all votes must be taken by roll call. There was also a clarifying provision added in SB 707 that says that if there's a disruption in service when you're engaged in a teleconference meeting, then you must basically put the meeting on hold until you're allowed to reestablish service so that you still have the opportunity for public comment and engagement in the meetings. So now let's look at one of the new teleconferencing provisions that's available for your commission's use. One of the new teleconferencing provisions is for reasonable accommodations. This is for if a commissioner has a mental or physical disability that would preclude them from attending a meeting at a noticed location. In that case, a commissioner may attend remotely as long as you follow the following requirements. So first, you must participate through both audio and visual technology. However, there is an exception that if you have a physical condition that would preclude you from using video, you can participate through audio only. The next requirement is that you must disclose anyone who is with you in the remote location that's over 18 years and your relationship to this person. And finally, because this is a reasonable accommodation to deal with a disability, this is treated different than the other teleconferencing rules, so those rules don't apply. So you do not have to post the location that you're meeting from. You do not have to take votes by roll call, although we would still recommend that because it's easier to have a record of what's happening. And you would count towards the quorum of the commission. So the next type of teleconferencing that's available to your commission are three that we'll go through. So we have proclaimed states of emergency, both state or local. We have just cause exceptions, and we have eligible multi-jurisdictional bodies. So for proclaimed states of emergency, this is something that was added to the Brown Act during COVID pandemic. And many of you, I'm sure, are familiar with those days when we had fully remote meetings, and these provisions still apply. And the new addition this year is that local emergencies are also eligible to have these types of teleconference meetings. So SB 707 adds a definition for local emergency, which is a condition of extreme peril to persons or property proclaimed by the governing body of the local agency under the California Emergency Services Act, or by a local health emergency declared in accordance with the Health and Safety Code. So these meetings, they can be fully remote, like I mentioned, but to do that, you must have a majority of the commission make a finding that meeting in person would present an imminent risk to the health or safety of attendees, and the commission must renew these findings every 45 days to continue to meet remotely during the actively proclaimed emergency. So hopefully this is something we won't see in the near future, but it is something that is available. And because these are emergency meetings, there is an exception where you can have these meetings by audio only. You're not required to also have video participation. So the next type of teleconferencing that's available is something that was new in 2022 and now has been extended for use until January 1st of 2030, and a few additional causes have been added. So for example, they added if you have to participate in military service, that would be a just cause allowing you to use this teleconferencing exception. Or if you're caring for an immunocompromised family member, that would also be another just cause for you to participate in this teleconferencing provision. So under just cause teleconferencing, a commissioner may appear remotely as long as, one, the commissioner has two-way audio-visual capabilities, meaning that the commissioner has a camera on and sound on so they can hear and participate in the meeting. The commissioner, again, must announce any person in the room with them that is 18 years or older in their relation to that person. And the commissioner must announce the just cause under which they are appearing remotely. So what exactly is just cause? Well, just cause is if a commissioner is providing child care services or caregiving services to a child, parent, grandparent, grandchild, sibling, spouse, or domestic partner that would require you to participate remotely. If a commissioner has a contagious illness that prevents them from attending in person. If the commissioner has a need related to a physical or mental condition that is not a disability that would be otherwise covered under the remote accommodation provisions. If the commissioner is traveling on official business of the commission or on business of another state or local agency. If the commissioner has an immunocompromised child, parent, grandchild, sibling, spouse, or domestic partner that requires them to participate remotely. If the commissioner has a physical or family medical emergency that would prevent them from attending in person, or if the commissioner has a military service obligation such as active duty or California National Guard or U.S. Military Reserve requirements that are 50 miles outside of the agency's boundaries. So in any of those cases, you can appear remotely using this just cause provision. However, you can only use it 2 times a year for this commission. Also, if you choose to use this, you will not count towards establishing a quorum. So a quorum of commissioners still must be present at one of the notice meeting locations. And I note this because you are a significant size commission, so it is important that if you're interested in using any of these teleconferencing provisions that you let staff know as soon as possible, just so that they can coordinate and make sure that we will have quorum available so that the meeting can go on.
Commissioner Nelson.
Yes, thank you. Just a point of clarification with a quorum. Is it a quorum in county or is it a quorum at a single location? Because for us here, we sometimes have it noticed at 2 different locations. Can you maybe clarify that?
Yes, so my understanding, and I will confirm this, but my understanding is that we can use any commissioner that is present at a noticed location within the commission's jurisdiction. So if you are present at either the Santa Barbara or Santa Maria location, we would use you to count towards the quorum. It's just if you are at a 3rd remote location that you would not be counted towards the quorum.
And just for an example, that mean that Commissioner Mosby today would be counted because he's in Santa Maria and that's a notice location.
Correct.
Okay, thank you.
So the next type of teleconferencing option that's available specifically to your commission is a new eligible multi-jurisdictional body option. So SB 707 establishes that eligible multi-jurisdictional bodies, which includes LAFCO, can utilize this provision until January 1st of 2030. However, to use this provision, the commission must adopt a resolution in open session at a regular meeting authorizing its use. So let's just take a little look at some of the specific requirements so you can see if this is something that you might be interested in. And if you are, we're happy to bring back a resolution for your consideration and approval. So teleconferencing under the eligible multi-jurisdictional bodies option requires that the agenda identifies the commissioner who will be participating remotely. The commissioner must use both audio and visual technology. So again, camera on, sound available so you can participate. The commissioner must identify anyone 18 years or older with them in the room and their relation to this person. All votes must be by roll call. The new requirement specific to this type of teleconferencing.
All right, come on, bring your.
I'm sorry, was there a question at all? Okay. So one of the new requirements that's specific to this type of teleconferencing is that a commissioner must be more than 20 miles each way from any physical meeting location open to the public, which, as we noted, since we have 2 noticed physical meeting locations in Santa Barbara and Santa Maria, any person using this must be 20 miles away from both of those locations. And finally, another requirement that is specific to this type of teleconferencing is that any commissioner using this would not be eligible for compensation for attending the meeting. This also has limits like just cause. So if this is something the commission had authorized using and a commissioner was interested in it, they would only be able to use it 2 times a year. And once again, the remote commissioner would not count towards establishing a quorum. So some of the other miscellaneous updates provided in SB 707 are in relationship to social media. So SB 707 eliminates the existing January 1st, 2026 repeal date for the social media provisions that were initially added in 2020, thereby extending them arguably indefinitely. Just as a little refresher, commissioners can use social media platforms to answer questions, provide information to the public, or solicit information from the public. However, a quorum of commissioners cannot discuss or deliberate on matters within the commission's jurisdiction by any means, including the use of social media platforms. And in addition, this specific to social media is commissioners cannot interact one-on-one with each other in regards to matters under LAFCO's jurisdiction on social media. So unlike in person where you can have like a Brown Act buddy or you can engage in a discussion with less than a quorum of the commission, on social media, you're not allowed to engage in that sort of contact, which includes commenting on posts or using digital icons like liking or using a thumbs up or thumbs down or posting some sort of emoji in response to comments. So it is more restrictive, and just note that for anyone out there using social media to be very cautious about how you use it. Another new requirement of SB 707 is that commissioners are provided with copies of the Brown Act. So we have done that today by providing you physical copies. They're also available online on LAFCO's website for today. A copy has been posted, and that's available for you. And it's also on the California Legislature's website, should you be seeking a copy of the Brown Act. Other provisions are for special and emergency meetings. Notice now must be posted on the legislative body's website. Before there were some limitations on when that was required, but it is now required in all circumstances. And finally, another change was that disruptive attendees on remote platforms can be removed using the same process that you can remove disruptive attendees in person. So basically that means that if someone is being disruptive in any means on one of our platforms that we're using to broadcast the meeting, the chair would need to issue that person a warning, telling them that they're being disruptive, and if they continue to engage in that behavior, that the commission can take some action. And we would recommend that we start with the least restrictive action possible. So usually we are able to put people on mute, so we would recommend we do that. If the person is continuing to disrupt the meeting, they can then be kicked out from the meeting. So it's the same process that we issue a warning and go forward from there.
If I might, hypothetically, if you put a person on mute, does that person no longer lose the ability to disrupt the meeting?
One would hope that that would resolve the situation if they were on mute, that they couldn't. But I'm not a technology expert, and I would assume that there might be some ways. I know that there's been Zoom blasting issues at some meetings that have accelerated issues. So
That would be
you
a
do have the option to
visual interference with the meeting as well. So I get that. I would offer the thought that if all possible, you do not want to throw somebody out of a meeting. You get in all sorts of trouble for doing that. If you can use a least restrictive means, I think the mute is the way to go on that. Thank you.
So those are the main changes to the Brown Act, and if you have any questions, or if you'd you can add to future agenda items to add a resolution potentially for the multi-jurisdictional body teleconferencing option if that's something you're interested in.
Well, thank you very much. I would ask Commissioner Johnson.
Yeah, I do have a question on that use limit of 2 times a year for commissioners based on the just cause. If you have a public committee meeting, do we have committee meetings here at all? Or any ad hocs? Because does that apply to that? I mean, I don't know. So that's something that I'd be curious to know.
Generally speaking, ad hoc meetings are not subject to the Brown Act because they don't involve a quorum of members. Yeah, I suppose if we had a standing committee, then that probably would, I would leave it to our council to tell you whether that would count toward the 2 times a year.
So Chair and Commissioner, I believe in that case, this is specific to the actual LAFCO commission meetings. So it would be 2 LAFCO commission meetings because it's based, the limitation is based on the number of meetings that the commission holds. So since this commission meets monthly, you get that 2 limitations. So it would be specific to this. You'd have to look separately at the standing committee, if you were on that, to determine what teleconferencing provisions they may be applicable to, and there may be separate limitations on those as well.
Are there any further commission questions or comments about this? I'd ask our chair and our council if it is at this point in order to entertain a motion with respect to bringing back that resolution that would activate the additional teleconferencing rules.
So Chair and Commissioners, this is listed as a business item, so I believe it's in your discretion to direct staff. So if you'd like to make that direction, you can do so at this time.
I would entertain a motion by the commission to do it. I think we should have a motion.
I'll make the motion. It gives us greater discretion going forward.
I'll second.
We have a motion and a second. Are there any comments from the commissioners on this motion? Not hearing one. Is there any public comment?
I do have a question.
Commissioner Nelson.
Yeah, so all it says is expand our opportunities. There's no offset for going down this route?
Chair and Commissioner is correct. It's an optional teleconferencing provision that's specifically eligible for your body, and it wouldn't preclude you from using any other teleconferencing options. It would just expand the options available to you.
Okay, so just greater flexibility for our members. Okay, thank you.
Is there any public comment as to this?
Chair Stark and members of the commission, there are no requests to speak on this item.
Thank you. We have a motion. We have a second. Madam Clerk, would you call the roll to bring it back as quickly as possible? I would assume due course of business.
Commissioner Guyer?
Aye.
Commissioner Hartman?
Aye.
Commissioner Kiriako?
Aye.
Commissioner Johnson?
Aye.
Commissioner Nelson?
Aye.
Commissioner Patino?
Aye.
Chair Stark?
Aye.
Motion passes unanimously.
Thank you. I thank council for that tidy presentation, and
May I just, I had a question, if I may, Mr. Chair?
absolutely.
So you started out saying that eligible legislative bodies, I think, were redefined in a way that LAFCO isn't one of those. So could you describe what's different for say, a Board of Supervisors or a City Council as opposed to LAFCO?
Sure, Commissioner. So if you are deemed a eligible legislative body now under the new provisions of the Brown Act, then there are additional requirements placed that you must comply with starting on July 1st of this year. And that includes providing interpretation services It includes some additional public access requirements for meetings. It includes translation services. So it requires certain applicable languages, which are defined as languages spoken by 20% or more of the applicable population, for the agendas to be translated into those languages. So there's a series of new requirements.
But mainly language access then. Okay, good.
And that does not apply, that particular requirement applies mostly to counties, cities, and some large districts, but not LAFCOs, is that right?
Correct.
Thank you. Shall we move on? The next business is business item number 5. Would the clerk please read that item into the record?
Commissioner Stark and members of the commission, business item number 5 is to receive an updated report regarding CEQA changes that took effect June 30th, 2025.
Thank you. Mr. Prater or Ms. Hardley?
So good afternoon. I will be providing you a brief overview of some of the key California Environmental Quality Act reforms from last year, which primarily came through 2 legislative budget bills, AB 130 and SB 131. Together, these bills contain some of the most significant CEQA revisions in recent history. However, their impact to LAFCO is likely limited. So why did we have this CEQA reform? So primarily for 3 reasons. The first is to address the ongoing housing crisis in California. The second is to address long permitting timelines and perceived CEQA litigation abuses, which caused delays to housing projects and increased project costs. And the third was that this was one of the governor's priorities to accelerate housing and other critical infrastructure. So based on that, both AB 130 and SB 131 were included in the state's budget trailer bills, which were effective immediately upon being signed on June 30th of 2025. So AB 130 is a fairly extensive bill. It's approximately 100 pages and has 74 sections. So this is going to be a 10,000-foot overview. So the key provisions of AB 130 are: 1, it creates a new CEQA statutory exemption for qualifying infill housing projects, which we'll examine more closely in the next slides. The second is it creates a streamlined approval process for housing on eligible sites. And the third, which is beyond the scope of this presentation, but just so you know, because it's a major component of the bill, is it creates a statewide fee-based vehicle miles traveled mitigation bank to mitigate transportation impacts on projects. So AB 130 created a significant new statutory CEQA exemption for qualifying urban infill housing projects. This provides a complete exception from CEQA for all aspects of a qualifying housing development project, including permits and public improvements required for the project. This new exception offers broader eligibility and fewer barriers for qualifying projects than the existing Class 32 categorical infill exemption, although that exemption remains in place and applicable for some projects potentially. There are several requirements to qualify to use this exemption, starting with project size, which can be no more than 20 acres, and project location, which is limited to qualifying sites, meaning that the site is urban, it's an infill site, and it is not in an environmentally sensitive habitat area, which means specific areas of the coastal zone, wetlands, conservation lands, etc. And it also requires mitigation measures if it were to be located on a hazardous area or a floodway or a very high hazard fire area or fault hazard zone. So there are several eligibility requirements to use this new CEQA exemption. So first, this exemption applies only to housing development projects, which are defined to include residential units, mixed-use development, where at least 2/3 of the square footage is designated for residential use, or 50% is designated for residential use when other conditions are met, for transitional and supportive housing, and for farm worker housing. Next, the project site must be located in the incorporated city or in an unincorporated urban area as defined by the U.S. Census Bureau. Next, the project site must be in an urban infill site, which in general means that the site has either previously been developed for urban use, or the site has at least 75% of the perimeter is in urban uses, or at least 75% of the area within a quarter-mile radius of the site has been used for urban development. Next, the project must be consistent with the general plan or zoning or coastal ordinances that are applicable to the project site. And the project must achieve at least 1/2 of the default density for the required location based on the Mullen density. For Santa Barbara County, the Mullen density currently is 30 dwelling units per acre, so an eligible project must have at least 15 dwelling units per acre. Some additional scopes and limitations on using this new CEQA exemption is that the project cannot involve the demolition of a historic structure that is listed on a national, state, or historic registry prior to the filing of a preliminary application. The site must be an eligible site for a project, as we talked about a little bit before, so it can't be on wetlands or farmlands, and there are some restrictions if it's in a fire hazard zone or on a hazardous waste site. The project cannot be used for transient lodging, so it can't be used as like a hotel, a motel, or bed and breakfast. There are some other limitations that we won't go into detail, but like if it was within 500 feet of a freeway, you cannot have balconies facing the freeway. And there are some labor requirements. So if the project is over 85 feet in height, then you must provide prevailing wages. Or if the project is 100% dedicated to lower income households, you also must provide prevailing wages. However, unlike a lot of other existing housing exemptions, there's no affordable requirement for this type of exception. And the project deadlines move very quickly, and we'll talk about this a little bit more, but for these new AB 130 projects, they have the shortest timelines for review and approval of 30 days. Also, the tribal consultation process is time limited for these types of projects, all in a goal for these things to move faster, to provide more housing throughout the state. And finally, a phase 1 environmental assessment is required as a condition of approval for development.
I have a question about the specific thing. What does it say about subprime ag land? Is that also subject to the exemption, or?
So, Chair and Commissioners, I'll have to look at that specifically. There are some limitations on ag land, but I don't recall subprime ag land.
Thank you. I think we'd probably appreciate it because LAFCO's got its own definition of prime agricultural land, and it'd probably be good to know if we're using the same definitions. Thank you.
So this chart is a modified version of a chart from Holland and Knight, and they provided a more detailed presentation of both of these bills. If you're interested, there's a link at the bottom here that you can watch that presentation if you want some more information. The key point of this chart is just to compare the new provisions of AB 130 and its exemption to the existing exemptions that are already available for housing projects. So as you can see, overall, AB 130 provides greater flexibility for housing projects to qualify for the exemption and has less restrictions on eligible projects. And then AB 130 is usually compared to the existing Class 32 categorical exemption used for infill housing projects. And when you compare, you can see that AB 130, again, is a more generous statutory exemption compared to the categorical exemption that Class 32 is, which means that as a categorical exemption, it's subject to possible exceptions, meaning that you would then have to comply with CEQA if there were cumulative impacts, significant effects based on unusual circumstances, circumstances, if you were near a scenic highway, if you had historical resources impacted, et cetera. And please note, there is a typo on the chart under class 32 in the EIR. If you follow that through, the box should say no, not yes, so my apologies. So there are several other exemptions for housing projects that already exist and can be used for qualifying projects. And this is one of the reasons why this change to CEQA may not likely have that great of impact on LAFCOs, but it does provide a faster and likely more affordable means of providing infill housing projects throughout California. So now let's take a look at SB 131 and what it does. So SB 131 is a much shorter law, but it creates several statutory exemptions from CEQA to facilitate the development of a variety of projects deemed socially and environmentally beneficial by the legislature that have arguably been limited in the past by CEQA litigation. So we'll go through the list of all these different exemptions in the next few slides. SB 131 also constrains CEQA review for projects that narrowly fail to qualify for a CEQA exemption. So this is called the new near-miss CEQA streamlining for housing projects. And this would also apply to AB 130's statutory exemptions. So if you weren't able to meet one of the specific qualifications for AB 130, you may still be able to do a near-miss limited CEQA review. Under SB 131, if a housing project would qualify for a CEQA exemption, but for a single condition of that exception, then CEQA review for the housing project is limited to the environmental effects caused by that single condition. Thus, the initial study or environmental impact for these near-miss projects is only required to examine environmental effects that are caused solely by the presence of that single condition that precluded its qualification from being exempt from CEQA. Further environmental impact reports for these near-miss housing projects are not required to include any of the discussion of alternatives to the projects or of growth-inducing impacts of the project. So for SB 131 near-miss streamlining review, there are some things that it does not apply to. It would not apply if you failed to satisfy a CEQA exemption due to the presence of two or more different conditions, if you're engaged in some sort of distribution center, if your project was oil or gas infrastructure related, or if you're located on natural and protected lands. And there is a definition for natural and protected lands, which is quite extensive, and I'd be happy to provide you a copy with that. But those include things like parklands, marine protected areas, wilderness areas, national monuments, national wild and scenic rivers, ecological reserves. So there is a fairly extensive list of lands that are protected, including environmentally sensitive habitat area and coastal zones, lands under conservation easements. So it is a fairly extensive list of things, and I am happy to provide that and more and look into some of how this works with ag land, since I know that's something you're interested in. So another exemption provided in SB 131 is for rezoning. So under SB 131, CEQA does not apply to a rezoning that implements a schedule of actions contained in an approved housing element. This could include not only rezoning to increase densities on sites designated for lower income housing, but also all other changes in zoning contemplated by the housing element, such as increases in height, parking restrictions, and increased density in single family areas. There is an exception, so it does not apply to rezoning that allows construction within any of these natural and protected lands, which I kind of went through some of the list on those. With the exception that rezoning of prime farmland is eligible for the exemption if it is included in the housing element schedule of actions. So next, SB 131 creates a series of CEQA exemptions that are not housing project related. So there are several exemptions. They include parks and non-motorized trail. They include wildfire mitigation. They include daycares. They include broadband deployment in right-of-ways. It includes some small-scale water systems and certain water and sewer infrastructure projects. And I would note that I'm talking about these in a broad way, but there are qualifications for each of these that are very specific. So just as an example, the exemption for parks is specific for facilities that are funded in part by the Safe Drinking Water, Wildfire Prevention, Drought Preparedness, and Clean Air Bond Act of 2024. So there are some limitations on each of these in terms of when you can use them, but they are all new provisions that are potentially eligible for projects going through the process. Some additional CEQA exemptions include nonprofit food banks, health centers and rural healthcare clinics, advanced manufacturing, the housing element rezones, and some agricultural employee housing. Another change that SB 131 made was to the CEQA administrative record when you're engaged in litigation. So SB 131 seeks to narrow the scope of what makes it into the CEQA record as a means to hopefully speed up the process of both compilation of the record and decreasing the cost of that. So specifically, it says that internal draft documents that are not shared with decision makers are no longer required to be included in administrative records. Again, there are some exceptions on this. I believe this doesn't apply to certain oil and gas and distribution center projects. But in general, it is a move to try to limit the length of some of these records. So some additional reforms that were provided in both, or either AB 130 and SB 131, are one, HCD, which is the state's Housing and Community Development Department, is giving greater control over the methodology to identify RHNA, which are the Regional Housing Need Assessment Targets. So I'm sure as y'all are familiar with, because housing element has been something that most jurisdictions have been working with for a long time, but on a regular basis, local jurisdictions are required to update their plans to accommodate housing development, known as their housing elements of their general plan. And they're required to accommodate a certain number of new housing units, referred to as the Regional Housing Needs Allocation. The process to determine each jurisdiction's RHNA is fairly complex and requires consultation and planning across local jurisdictions, regional government associations such as SBCAG, and with HCD. AB 130 gives HCD greater control over this process by requiring each regional government organization to follow HCD's direction and obtain HCD approval for its methodology to allocate RHNA across local jurisdictions. Another significant change is that there's a building code freeze until 2031. So basically, with minimal exceptions, state and local building codes cannot be updated for the next 6 years to provide some certainty and relief on housing costs. Another provision is that SB 330, which is the Housing Crisis Act of 2019. A lot of those provisions are now made permanent. A lot of them were scheduled to sunset in the coming years, and now these limitations have been removed. So I don't know how deeply you guys get involved with that, especially on a LAFCO level, but for anyone who's familiar with this, it means that the provisions requiring a maximum of 5 public hearings for certain types of housing projects. Those provisions continue on indefinitely. The requirement to have completeness lists, again, continue on indefinitely. Another key change is that ministerial approvals are subject to the Permit Streamlining Act. Before, only discretionary approvals were, but now ministerial housing approvals are. So again, it's all a means to try to get these types of projects to move through the process faster. So just a little background. The Housing Crisis Act of 2019, commonly referred to as SB 330, created new protections and procedural safeguards for housing development projects. Most notably, upon the submittal of an SB 330 preliminary application, a housing development project will vest all applicable ordinances, policies, and standards in effect at that time. SB 330 also provides a limited set of circumstances in which a housing development project will lose vested rights. However, with the submittal of SB 330 applications, it also triggers deadlines subject to the Permit Streamlining Act, or PSA, again, in a means to facilitate timely review of these housing projects. So all these provisions were to sunset in 2030, but now are available indefinitely. And specifically in the Permit Streamlining Act, it allows that local government agencies adhere to strict timelines for reviewing and approving or disapproving of development projects. Now, the term development project has been expanded to include ministerial housing development projects requiring an entitlement permit. So this could be ADU applications, those sorts of things. But the part that you may find interesting is that in these goals to expand the Permit Streamlining Act, they actually did expand some of the provisions to be applicable to LAFCO. So specifically, in SB 489, which became effective on January 1st of this year, it for the first time makes LAFCO subject to a very limited portion of the PSA for specific housing development projects as follows. So first, it requires that public agencies publish online for each approval it issues in connection with a housing development project the list and criteria the public agency will apply to determine the completeness that are required under existing law. And second, it requires that LAFCO's written policies and procedures, including any forms necessary to complete applications concerning a proposed change of organization or reorganization, also be posted on LAFCO's website. But the other provisions in regards to specific times to act are not currently applicable to LAFCO.
Dare I ask if our forms are in fact available in our detailed handbook or otherwise in our website?
Chair Stark, our policies and forms are all available on our website.
So we're already in compliance with SB 489, if
We
I
are.
hear you right. Yay, yay.
So the key takeaways are that this major SEQA reform that occurred is there should be faster housing project approvals. SEQA review will be limited for these housing projects, and to the extent that any of these projects come to your agency, you would likely have been a responsible agency, and that will limit your ability to add mitigation measures potentially to these projects. However, you still retain all the discretion that you have to condition projects as you deem necessary under the Cortez-Knox Act. And finally, there are now multiple CEQA exemptions and project streamlining paths available for housing and other key infrastructure projects. So maybe we'll see some movement in different projects in the future. Thank you.
May I inquire if there are any commission questions or comments on the CEQA presentation? I may have missed the last thing you said. I have a question about whether this spate of laws increasing the exemptions for housing thing changed in any really material respect our responsibilities as responsible agencies?
So Chair and Commissioners, no, it didn't change any of your authority or actions as responsible agencies. The only thing that it would change is if a project was eligible for an exemption, then as a responsible agency, you would also look to ensure that the project, when it came to you for the decisions you are making, also qualifies for a CEQA exemption. And in that case, then you wouldn't be able to add mitigation measures or require additional environmental review.
Thank you. So it sounds like it directly doesn't really affect us a great deal. it probably is going to affect significantly the rate at which housing proposals are processed in the cities and the county. Anything else? Do we need to do anything other than thank our council? Good report, fine PowerPoint, exception to my usual loathing of PowerPoints. It was quite clear. I do have one related question. Is my understanding correct that the next meeting we're going to consider adding some sort of eligibility for reimbursement for an online CEQA conference from UCLA? Is that right? And we can deal with that next week, next month?
Yeah, that is correct.
We don't have to do anything here.
No, February we'll have an action item for the commission to consider.
Thank you. I declare this received and filed. If that's okay, and we could move to business item 6, I believe. Would the clerk please read that item into the record?
Chair Stark and members of the commission, business item number 6 is to receive a presentation and status update regarding Richard Ranch application.
Mr. Prater?
Thank you, Chair. Commissioners, the long-awaited item here. The commission requested this status update of the Richard Ranch proposal, largely based on written comments that were received at our November 6th meeting. At that meeting, those comments were submitted to the commission, and staff hadn't had time to fully review those. And the commission added it to a future agenda item with concurrence with the broad commission. Largely, those comments express concerns, particularly over the procedural steps that application has gone through, and some of the terms of the tax negotiation and what was being asked out of that process. So I prepared a report that kind of documented what that application has gone through, the procedural steps that have been prepared. And so that's what's identified in this report, and I'll verbally discuss what those are. Essentially, the city submitted its application for the Richard Ranch development in January of '25. A report back was generated. This is the referral within the tax process that initiates that process. That report back was sent out on February 14th. It initiated that 45-day to start the negotiation period. That date was March 30th. From February 14th to March 30th was that date in which the county auditor's office needed to prepare their notice of tax estimates. That actually happened on March 28th. So 2 days early, the county was able to get that notice put together, and they effectively started the negotiation period. Essentially, immediately with the start of that date, the county requested and sent both to the city party and to your executive officer a request to extend the negotiation period from 60 days to 90 days. With that request, it's simply a request. Immediately when it's requested, it's granted. There is no discretion to say no or not. If a party needed more time, they could ask for it. They happened to ask for it. With that, staff prepared and presented a study session, which we held at our May 8th meeting. Prior to that, initial review and communication was referred back and forth between the developer and the applicant, the city, about the property tax agreement and its process and where it started and where it's at. All of that information was communicated back and forth. Ultimately, we indicated that a property tax agreement hasn't been completed and that the map and legal descriptions haven't been signed off by the surveyor, which ultimately put the project incomplete and failure for us to issue a certificate of filing. We held that study session. We used that study session to garner additional input. That may have been an opportunity to lead to new information needs that the commission was requesting. At the conclusion of that, the commission didn't request any additional information, but they did were concerned in monitoring of the process and what was going on. At the close of the 90-day period, for which was requested by the tax exchange agreement process, they were not able to reach agreement from both parties. At that point, the agreement was extended, and on July 17th, there was a request by the city to enter into mediation. Both parties agreed to extend the mediation period up until October 31st. At the conclusion of that, the parties agreed to enter into arbitration. We're currently in the arbitration period, and the parties can agree to extend that period, and it's an ongoing period until the parties conclude the outcome of that decision. At this point, when either party informs LAFCO of whether an agreement's been reached or no such agreement can be reached, we will proceed to the next steps that need to take place pursuant to the act. And that is either we'll hold a hearing or we'll have to terminate the application. So that concludes the status of this application and where we're at and how LAFCO staff sees the proceedings that have taken place. Happy to answer any questions.
Thank you. Are there any questions from or comments from commissioners?
I have one.
Commissioner Hartman.
Thank you. So what is the difference between mediation and arbitration? Usually arbitration is binding, but apparently not here.
Correct. Mediation is a process where you get an independent mediator to hear both sides and try to bring both sides closer to a middle point. Arbitration is a process in which both sides make a final plea of what they want to see in the agreement, and an arbiter will evaluate those and choose one that he feels is best suited for the case.
But it's not binding?
But it's not binding, right. If one party disagrees with the arbiter's choice, they can proceed to a hearing and adopt findings to the contrary of why it would be detrimental for them to enter into that arbitration.
So it would arm a party going to the court? I mean, with the arbitrator?
Yeah, at that point, you're developing those findings to support your case and any future litigation that may come of that.
Are there any requests from the public to comment on this matter?
Commissioner Stark and members of the commission, there is a request for public comment here on, it is a video. So I will see if I can get it to play.
I believe I recognize the...
Good afternoon, Chair Patino, Commissioners, and staff. My name is Michael Stolte. I'm the managing member of Richards Ranch. First off, I just want to apologize for not being able to be there in person. I had prior engagements and I'm out of state, so thank you so much for letting me record this and send it in. It's a very important item for us, and we would very much like to be there in person. You know, we began working on this project back in 2020. When we did, we looked at this site and its 18-year history of having a lot of conflict regarding the site not having water within the county of Santa Barbara. Walmart essentially tried to get it resolved for about 18 years before we purchased the site in 2021. We did our own due diligence to see if we could accomplish a project within the county, which obviously would have been a much simpler process. But that was not something that we felt was possible at the time, given the water challenges of the site, as well as the fact that it was already in the city sphere of influence. Typically, you would see projects of this scale be annexed into cities because of the urban services, etc. So, we've spent years working on this. We've invested well over $1 million in its process. We have a fully approved EIR for the annexation. We received approval by the city of Santa Maria for annexation. The application was submitted to LAFCO, I believe, in January, and the tax exchange process should have started in March. Typically, the tax exchange process is a 60-day process at most. Usually, they happen even quicker than that. What's unique about this is that basically an identical site, which is Key Site 25 off of Santa Maria Way, was annexed in 2007 and has a predefined tax exchange. It is very common for those tax exchanges to be used on a go-forward basis. At most, a few negotiated items would change, but 60 days is plenty of time for this to happen. Additionally, the county asked for an additional 30 days, which would have put this ending in June. Here we are beyond 6 months of that. We've had a failed mediation, and as far as I know, we're not aware of any time that this county and city has ever gone to an arbitrated agreement. We think that taxpayer dollars have been wasted. We certainly have been challenged as owners on this project. We're trying to get a housing project done. We'd ask that LAFCO weigh in on this situation. Our concern is that there's an attempt to keep LAFCO from essentially playing its part in this process. And so we have a lot of concerns, and we'd like to be seen at LAFCO as soon as possible, and we'd like to see this completed. Thank you.
Thank you. Thank you, Mr. Stolte. Are there any further questions? My understanding is we can't do anything about this unless and until there is a tax exchange agreement or some other defining resolution. That's the way Cortese Knox Hertzberg works. Correct me if I'm wrong here.
Chair Stark, you are correct. There is no additional role for LAFCO to play until after some agreement is reached or the conclusion is no agreements can be reached. That's at which time we can continue the proceedings of this application.
And to be candid and to be frank with Mr. Stolte here, I got a whole lot of questions about this, but I don't see any point in asking them until we have jurisdiction over this project. I think that's where it is. Anything further? This being an information, is this not an information item? It's actually noticed a business item. Is there any motions to be made? I assume there's no public comment other than Mr. Stolte?
Chair Stark and members of the commission, there are no other requests to speak on this item.
Thank you. I'm not sure we need a motion on this. I wouldn't think so.
Yeah, no action is needed.
No action is necessary. Probably won't take any. Should ask the clerk to call business item number 7.
Chair Stark and members of the commission, business item number 7 is to consider selecting voting delegates for the 2026 Cal LAFCO Special Corporate Business Meeting.
Thank you. Mr. Prater?
Thank you, Chair and Commission. As I indicated in an earlier presentation, Cal LAFCO will be holding a special corporate business meeting on February 23rd. It's a virtual meeting. Each LAFCO must appoint a voting delegate and alternate delegate to be able to attend and cast a vote at that meeting. And so this item is placed before the Commission to identify a representative to be able to attend virtually on the 23rd and be able to cast our vote on behalf of Santa Barbara LAFCO. Mostly what the Commission Board's going to be considering is additional bylaw changes. We approved some bylaw changes back at the annual conference. And now there's some additional bylaw changes as cleanup that are being proposed. And ultimately, I think they're proposing a new regional map. The commission hasn't seen that regional map. We intend to bring that at our February meeting for your consideration so that the appointed delegate or alternate will have a better understanding of what that looks like. So with that, we'll conclude our presentation, and we look forward to an appointed delegate.
I have a couple.
Are there any questions? Commissioner Hartman?
Does the alternate have an opportunity to speak, if not vote?
All members of the commission are members of Cal LAFCO and have an opportunity to speak at any of these events. We can all attend virtually. If the delegate is present, their vote will count. If that delegate has to step aside or can't make the meeting as a last minute, then the alternate would step in and make that.
Our county gets one vote. Our LAFCO
Our
gets
county
one
gets
vote.
one vote, but we all have a voice.
Well, it seems to me that Commissioner Stark and Kiriako have the most invested in this, and I think we would be well represented. I don't know who would want to be which position, but I'll put you on the spot.
I'd happily be the alternate.
Yeah, I probably logical that I be the regular person. And you're a chair, you're a leader. Yes.
So I would make that motion.
I would second. Nelson seconds.
There any requests from the public to speak on this?
Commissioner Stark and members of the commission, there are no requests to speak on this item.
And are there any other comments from commissioners or any of that? Haven't heard any. Would you call the roll, please, Madam Chair? We have a motion and a second, I believe.
Commissioner Guyer?
Aye.
Commissioner Hartman?
Aye.
Commissioner Kiriako?
Aye.
Commissioner Johnson?
Aye.
Commissioner Nelson?
Aye.
Commissioner Patino?
Aye.
Chair Stark?
Aye.
Motion passes unanimously.
Thank you. The next item is information item number 1. Would you please read that into the record?
Chair Stark and members of the commission, information item number 1 is to receive and file an oral report on the special district election.
Mr. Prater.
Thank you, Chair and Commission. This is an oral report, largely because the deadline to file for nominations didn't close until January 2nd. And so we didn't really know the conclusion of that at the time the agenda packet was needing to be produced before the Christmas period. But that has now since closed, and we have 2 nominations that were received by that deadline. First nomination was from Montecito Sanitary District to renominate their board member, Doreen Lee Johnson. And the second was Mr. Robert Dunlap. He was from the Santa Ynez River Water Conservation District. So we've started a 45-day election period. Ballots have been sent out. That started on January 5th. And that will conclude, that 45-day will conclude on February 19th. If at least 19 votes are received by then we'll have elected its new member. The special districts will have done so. And so we'll keep the commission up to date on what that process looks like, and we'll submit the materials of the nomination packet at our February meeting so that you have those. I will note that unfortunately we did have a typo. I had a typo in the district's name. Santa Ynez River was misspelled, so the river was misspelled. But however, we had already received ballots back with that typo, and so I didn't reissue a new ballot. It was not enough of a typo that caused any of the voting members to not understand who the representative was or where they were from, so I felt like we could move forward, even with that misspelled river. So that concludes the informational item for this matter, and as I indicated, we'll keep the commission up to date at our February meeting and show you what that packet and nomination looks like. And by February 19th, we hope that we have enough votes. And again, as a reminder, if not enough votes are cast, we extend the voting period beyond that until we can get enough votes. That
Thank you,
concludes.
Mr. Prater. Are there any commissioner questions, comments? I don't hear any. Any public comment?
Chair Stark and members of the commission, there are no requests to speak on this item.
Thank you. This being an information item, no motion is necessary. So we should move on to information item 2. Would the clerk please read that item into the record?
Chair Stark and members of the commission, information item number 2 is to receive and file a report regarding Cal LAFCO LAFCO 101 session on February 25th, 2026.
Okay, thank you, Chair. This is to inform the commission that the Cal LAFCO U session for 2025 has begun. We often attend these. This is going to be a virtually held LAFCO 101 session on February 25th. All commissioners and interested members that want to attend that session can just simply log in to the Cal LAFCO website and register yourself. If you need help with any of that registration, please reach out to staff. We'll help get you registered before that deadline. The deadline for that is, I believe, going to be just a few days before the February 25th. As of right now, they don't have a limitation on attendance, but that may be something that's forthcoming from Cal LAFCO, the youth course. If the seats are going quick, we'll let you know, and anybody who wants to get registered, we'll try and get you registered.
This is the good old LAFCO 101, right?
This is the LAFCO 101. I'm not sure if
No
it's...
game shows.
I'm not sure if
on
it's a
the-
game
on-
show
no-
format this year.
No game shows on the.
Unless they've invited you to continue your celebrity status.
No,
on
they
the
did
game
not.
show.
They've learned their lesson about my celebrity status.
I do think it's a different format than what you traditionally have, but it's a good opportunity for any new commissioners that weren't able to attend the conference to get a refresher on LAFCO 101 and what our role is. And the folks that are putting this together, as you see, it's Joe Serrano with Santa Cruz LAFCO, and it's Paula from the BB&K. So they're usually pretty good. So if you want to attend, let us know. We'll try to get you registered, or you can register yourself when you think you're ready to go.
Any comments, questions from commissioners? Any public comment?
Chair Stark and members of the commission, there are no requests to speak on this item.
Thank you. I don't think we need a motion on this. So we should proceed to the next item, which is a closed session. And would you like me to read it, or do you want to read the closed session? I'll do it. It's a closed session today for conference with our labor negotiators under Government Code Section 54957.6. The agency designated representatives, or our chair, that would be me, I guess, and our counsel, Ms. Holderness. And the session is about one unrepresented employee, Mike Prater, the executive officer. We will return after a closed session for any commissioner announcements, and then we will adjourn. Shall we move to closed session? We met in closed session. We took no reportable action, gave direction to our negotiating team. And that brings us to our next item, which I believe is call for commissioner announcements, requests for additional items. Is that correct? Anybody, any commissioners have any?
Yeah, if you'd like to add anything in addition to the two items that are listed, just an update, which I'll include as my EO report as well. The Isla Vista CSD powers and authority, we are working with the district and trying to target returning at our March meeting for the commission. That'll put us back here. That'll make that more of a local meeting for the representatives from Isla Vista CSD to be able to attend in person. And the update on SB 499, we anticipate bringing back at our next meeting in February. Considering we'll check in with our legal counsel if they have time to be able to help us prepare that report. But essentially, we hope to wrap up all of those future agenda items that the commission has placed. But if there are additional ones, now's the time to ask for more.
Thank you. Anyone else? In that case, I would declare that we are now adjourned to Thursday, February 5th, 2026 at 1:00 p.m. at the Centeno Center in Santa Maria.